I'll call the second case on this morning's docket, case number 117654, State of Kansas v. Curtis Ayers.
Good morning, Your Honors. May it please the Court. Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Ayers and Chief Justice Nuss, if I could please have 3 minutes rebuttal.
3 minutes is granted.
Thank you. By way of a brief factual summary, Mr. Ayers was charged with capital murder and 9 other pretty serious felonies, all surrounding the killing of a Kansas City, Kansas police officer. He pled guilty pretty much straight up to all of that to avoid a death penalty trial. And the plea agreement said that all parties agreed that his sentence would be life without possibility of parole, but everyone was free to argue within the limits of the law as to the on-grid sentences, as to what his sentence for those would be. We got to sentencing, and without doing much of an inquiry other than asking the defense attorney where we are on bids fees, the district court awarded $1,000 in bids fees along with roughly $4,000 in restitution and other fees. Mr. Ayers was also sentenced to 492 months for the on-grid crimes, and the district court judge chose to run that consecutive to his life without possibility of parole sentence. I think this case is extremely straightforward, so I don't want to waste the court's time today. I do want to make 3 quick points, basically. First of all, as to the bids fees issue, it's a pretty simple resolution. The court didn't consider it. We have Robinson. It's been good law for over 10 years now, and I think we can stop there if we want to. The state is urging this court to kind of make a de novo review of that question, and I don't think this court is even in a position to do that. The state's arguing that we have some sort of absolute knowledge about Mr. Ayers' finances because he's going to prison, but I don't think that that's correct. I think it's very easy to say this person's going to prison, so they're going to have no bills, they're not going to have to pay rent, but he still has room and board that he has to pay. He has forced savings if he gets a job. I mean, there are a lot of unknowns in his financial situation. He also, I was looking back at his original affidavit of indigency, and it looks like he has some child support obligations as well. So the problem is we just don't know because the district court didn't make those inquiries. So I don't think that this court is really in a position to reconsider that, even if statutorily you could, which we've argued that you can't. Third, the state has argued that bids fees are the same as restitution somehow, which I think I said it out in the reply brief, so I'm not going to repeat it. Those are completely different things. With that, if there's anything else the court would like me to address, I'd be happy to. Otherwise, that concludes what I had prepared to talk about.
Do we have any questions? All right. Thank you, counsel.
Thank you.
May it please the court. Like previous counsel said, this is a fairly straightforward case. I will not stand up here and say that the judge made any sort of factual findings before imposing the bids fees.
Counsel, before you continue, for the benefit of people watching on their computers, could you announce who you are and who you represent?
Yes. I'm sorry. I'm Ethan Zivsigler from the Wyandotte County District Attorney's Office. I do not believe it's a de novo, or that this court should decide it de novo. I was more trying to argue that while I acknowledge that there is absolutely a different standard of review or standard and burden when you are imposing restitution, this is an unusual case in that we can foresee the defendant's financial obligations and his financial wherewithal for the rest of his life, and there is simply no more inquiry to be done by the court. The moment the court said you are sentenced to life without the possibility of parole, all inquiries were essentially done. We could predict what was...
I have at least a vague memory of several times where the state has argued in restitution cases that we don't know what's going to happen in the future with the prisoner. They may win the lottery, they may get an inheritance, etc. Aren't those things also true of this person?
I believe yes, those would be.
That's the problem. You're kind of wickered by
Sure.
all those legions of arguments that have preceded you. Okay, thank
And
you.
I felt it was sort of a novel case in this case because he is sentenced to life without parole. We've considered restitution, but most in lifetime sentences, but most of those are life hard 50s, life hard 25s, and this is I believe this might have been the first case I'd seen where it was a life without parole with BIDS fee specifically.
Well, life without parole plus another, 20, 30 years? After Daddy's got to serve consecutive 20,
Yes.
30 years? Yeah.
And again, it's sort of a novel issue, but I will not stand up here and say that there was much of a factual finding before the BIDS fees were imposed. I think we all read the record. As to the consecutive sentences, though, aside from citing Kleypas and the fact that this court has not overturned sentences where on-grids were run consecutive to a death sentence, I will say that I do think that there is something to be said for, the judge was in this case trying to make an account for every action that was committed by the defendant. And beyond the death of Brad Lancaster, who was the officer in the Kansas City, Kansas Police Department who was killed, this defendant went on a series of criminal actions after that, including burglarizing a car in which there were at least one young child in the back, and went on the run from police for a while that ended in Missouri. And even though there's no actual sentence that will be served after the defendant dies, there is something to be said to telling those victims that your story matters too, your pain matters too, and what happened to you matters too. And I think when we look at cases where judges have run multiple off-grid sentences consecutive to an extent that no human being could possibly live, there is an argument that reasonable people can say consecutive sentences, even when those seem ridiculous, do try to account for what has actually happened in a case and try to make a judicial record of what's been done. And I think a reasonable person can run those counts consecutive, and reasonable judges have in the past. So there wasn't an abuse of discretion here. And unless there are any other questions, that's all I have.
Any more questions? Thank you, counsel.
Your Honors, may it please the court, Meryl Carver Almond. If you have any specific questions for me, I'd be happy to answer them. Otherwise, I would waive rebuttal.
Any objection to her waiving rebuttal? All right, thank you,
Thank
counsel. Thank both of you for your brief arguments this morning. Court will take this matter under advisement.